I'm going to call the first case on the docket, which is People versus Jennifer Ann Monroe, docket number 357631.
Morning, Your Honors. May it please this honorable court, Alona Sharon on behalf of the appellant, Jennifer Ann Monroe. Welcome to Judge Patel. It's nice to see you. I'm sure this will be the first of many because I'm a regular here. Your Honors, I know that the court is, although I didn't hear the regular spiel this morning, I know the court is always very familiar with the briefs and the arguments that are before the court. But I do want to take just a few moments to address some of the argument and case law that was presented by the prosecution in its brief on appeal. Particularly two of the cases that are cited by the prosecution, People versus Perenboom and People versus Elliott. First, as it relates to People versus Perenboom and why I think it's not really applicable to Ms. Monroe's case. First of all, I think the Perenboom decision with respect to whoever authored it is just very light on the facts, and it makes it very hard to know whether or not it's really analogous or distinguishable from Ms. Monroe's case. There's a very cursory treatment of the Miranda issue in that case. We really don't know if there was an arrest or a formal restraint, and I don't even think the decision tells us whether or not Miranda was given in that case. So it does make it very difficult to know whether or not it's factually analogous to Ms. Monroe's case. The other part of the decision that I think is really distinguishable is the voluntary analysis in Perenboom. And that is because the panel in that case makes it very clear that they strongly defer to the trial court's review of the evidence and the witnesses. And I think Perenboom dates back to 1997. But what we know is that from this court's decision in 2017 in Kavanaugh, docket number 330359, which was a published decision, is that this panel can review the evidence, such as the recording in this case, and make its own determination if the trial court's finding of facts were accurate, given the record that was before it. In Kavanaugh, it had to do with a traffic stop and a Fourth Amendment issue, but it applies the same here. The court was provided with USB drives with recordings of the interview of Ms. Monroe. It can certainly tell from that recording, at least I would argue, that she was under a tremendous amount of pain and distress. She required medication during the interview due to the high level of pain that she was experiencing. So while the trial court in Ms. Monroe's case may have come to the conclusion that she was just dandy during the interview, I think certainly the evidence that is before this court and that this court is able to review on its own should come to a different conclusion from the trial court. So for those reasons, I think Perenboom is distinguishable and this court should not rely on it respectfully. Also, I think in Perenboom, the doctor testified that the medicine did not impair the defendant in that case, and the defendant refused to answer some questions, and so that undercut the voluntariness argument. As it relates to the Elliott case, so the Elliott case is very distinguishable because in that case, we're talking about a parole officer who encountered the defendant for 15, 20 minutes tops, but also, and this is something that it's very clear the court heavily relies upon, doesn't go for the purpose of interrogating the defendant, but goes for the very narrow purpose of advising the defendant about a parole violation, advising the defendant of his rights, and finding if he's willing to waive a preliminary hearing as it relates to the parole violation. There's really nothing in the record to indicate that the parole officer went to see the defendant for purposes of interrogation, and it really wasn't foreseeable that the defendant would then spill his guts about this armed robbery that's at issue in Elliott. So for those reasons, I think those cases are very distinguishable and not really applicable to this case. But the case that is applicable that I relied upon as it relates to voluntariness is Mincy versus Arizona. And when you look at the condition that the defendant was in that case, it really is no different than Miss Monroe, hooked up to machines at the mercy of the police, having just undergone surgery, having been given a tremendous amount of pain medication. He was at the mercy of the detective. I think that's a direct quote or very close to it from that case. And there is no difference. There is no distinction here for Miss Monroe. And also, I think what is remarkable is that when given the option, when she was actually given the option of, do you want to talk to me, right? Because we know from the Walker hearing that Pettigrew, Officer Pettigrew, or maybe it was Detective Pettigrew, when he actually posed the option to her of, do you want to talk to me? She declined that invitation. But it's when the other two detectives come at her, uniformed, armed, flanking her hospital bed, and she is literally confined to that bed, right, by way of tubes and whatever. I'm not a doctor, but you know, and she can't escape it. It's,
Wait.
yeah,
She might not have been able to leave, but she could certainly decline to speak with them, correct? She could.
she could have, although she
She
was
did-
not advised of that.
Well, she already exercised that right already with the first detective, right?
That is correct.
So she was aware that she could decline.
She was aware hours earlier that with that detective, she could decline, but certainly these officers never advised her of that, nor did they ever advise her that they would leave the hospital room if asked to. And that was not something, there was nothing in the record to indicate that Pettigrew, Officer Pettigrew, had advised her of that
Right.
either.
Yeah, so I think that's a little fast and loose with the facts there.
In terms of what?
That she was able to decline in one circumstance, which meant she was aware that she could decline in the second circumstance. So the fact that she couldn't physically exit the bed doesn't mean she couldn't exercise that right to decline to speak to it's the only point I'm making.
Sure, and I think, and I completely accept the point that you're making, Judge Kelly, but I also think that in that passage of time between her experience with Officer Pettigrew and then the subsequent detectives, I guess I would just ask the court to be mindful of the fact of how much medication she had been given.
No, I understand your argument. I'm
yeah.
just saying your argument was a little different then.
Okay.
Okay.
So, Your Honor, and also just turning to the custody and Miranda issue, I would argue along the same lines as the voluntariness argument that she was in custody. I think someone certainly in her condition would not have felt free to leave. Certainly factually, we know she wasn't free to leave. And for those reasons, she should have been given Miranda, and the trial court's analysis was erroneous on both fronts, both the voluntariness and the Miranda analysis. If the court has no questions, I'll reserve whatever time I have for rebuttal.
Questions?
So the court would like me to quickly wipe down before.
Yeah, I think that would be a
Okay.
nice, polite thing to do.
I am nothing if not polite.
Just so that everyone else knows, we're going to ask you just to wipe down the podium every time you depart from it.
I will say that.
And masks are now optional in our building, so you can wear one at the council table if you wish. It's totally up to you. Or at the podium. Again, that's your choice. Thank you, Ms. Sharon.
Yes.
Good morning, Your Honors. My name is Nicole Robertson. I'm prosecuting attorney from the Shiawassee County Prosecutor's Office. I represent the people, the appellee in this case. As you know, we're asking you to decide two decisions today, whether it was voluntary, the defendant's statement, and whether or not defendant was in custody and as such needed Miranda warnings given to her. Briefly touching on what Ms. Sharon just discussed, people v. Perrenboom and Elliott. Going to Elliott, of course, it is always the option of this court to review the evidence and make your own determination. Absolutely, that's what we expect. Of course, it's always up to you. Understanding, the norm is the standards to look to the lower court and see what their decision was and why. Of course, we understand that it's always
Yeah,
up to
and
you.
looking to the decision of the lower court, what troubles me about it is that we had expert testimony presented by the defendant regarding the defendant's medical condition, which made it absolutely clear that she was mentally incapacitated at the time these detectives were questioning her. We have a court that found otherwise with no evidence to support the court's finding in the record. As far as I can tell, the court basically became its own physician for the purposes of this hearing, of the Walker hearing, and made its own decision, but did so absent any testimony that would have supported its findings. What do we do with that?
Your Honor, going to the testimony of the doctor, Dr. Miller. The trial court judge just agreed with the defense's medical expert, Dr. Norman Miller, for a couple of reasons. In his affidavit, he stated he did listen to the audio. When he got to the hearing, he said he didn't recall it.
That doesn't, I know you make a big deal about that. Can you explain to me? I've thought about it and thought about it. What possible relevance does that have to whether or not the drugs that she was given and the condition that she was in were such as to make her essentially chemically incapacitated to give a voluntary statement? So what? He listened, he didn't listen. Big deal. I don't get that at all.
Your Honor, Dr. Miller did mention in his hearing that he believed it was possible his opinion would change if he had listened to the audio as well.
Well, isn't that the point, though, that these drugs may have had this effect, but he couldn't make the connection between what he thought the drugs did and her condition because he failed to listen to the audio. And then he mentioned that in the exam or affidavit, I can't remember, that it may have changed his mind if he had actually listened to it. So there was a failure of connection between the medication and her statements. And the trial court had actually listened to this, right?
Yes, Your Honor.
And he mentioned, and the trial court mentioned that specifically, that her lucidity during the conversation was evident that she wasn't that impacted. Correct?
Yes, Your Honor.
Okay.
The trial court judge did go into further detail on that, specifically noted throughout her speech was articulate, noted she went over dates and details of her childhood, spoke about her relationship.
With her brother
even-
too or something, right?
Pardon?
Didn't she talk about her brother moving in?
Yes.
Yeah. Okay.
Spoke about her brother, even joked with the officers at one point. So therefore, in consideration of the sophisticated language, the thought processes, the depth and breadth of her conversation throughout with the officers, the judge found that her medical condition did not impair her judgment. Also noteworthy, going to defense counsel's note as far as voluntariness, the victim continued talking. Detective Rusty LeMay in his hearing mentioned that they asked her open-ended questions, him and Detective John Cecil, and that in fact she was quite talkative. He also testified that she did not ask them to stop nor say she wanted to leave. That all goes to the voluntariness of her interacting, talking and answering questions. Trial court judge also noted defendant's will was not overborne. Of course, she didn't ask for the interview to end, didn't stop speaking, and believed her not to be incoherent. The judge looked at the 7 factors from People v. Cipriani, the totality of the circumstances, considering officers did not treat her abusively. She spoke intelligently. There was no coercive police activity. Miranda was not required to be given at that point. The questioning was brief. There was only approximately 2 hours compared to some of the other cases we've seen where it's gone on for days or many hours at a time. There was no significant delay before questioning, and the defendant was not detained before questioning. That's all as far as issue 1. As far as issue 2, whether or not Miranda was necessary, the trial court judge deemed she was not in custody, and therefore Miranda was not required to be given. Referencing a couple different cases, People v. Zahn, judge noted that the issue was whether the accused felt free to leave, and the determination of custody depended on the objective circumstances of the interrogation, rather than the subjective views of the officers.
Is it your position she could leave?
Your Honor, we believe technically she could have, because while she was not restrained by police, she was hooked up to machines. There was no indication that she could not walk.
Well, there
As
was
well.
she received her 5th dose of morphine that morning or that afternoon while she was being interrogated, or just before she was being interrogated by the detectives. She was hooked up to machines. She had catheters in place. Is it really your position that she could leave?
Your Honor, that she had the option. The officers were not closing the room off from anyone. Hospital staff was coming and going throughout. Family could come and go if they wanted to. No one else came in other than hospital staff. And in fact, at one point, Detective Rusty LeMay did ask hospital staff, is it okay that we talk to her? And they said, sure, she's fine. So they did check in first as far as her condition. The judge also noted under Rhode Island v. Innis, a Supreme Court case, interrogation involved question that police knew or should have known would give an incriminating response. However, he deemed her not to be in custody, looking at factors as was her freedom of movement curtailed, which Your Honor just went over, thank you, and whether or not there was the same coercive pressure in the instant case as in the station house in Miranda. And he believed that there were not the same coercive pressures. Additionally, the judge cited People v.
Well,
Parent.
I would argue, counsel, that actually there were more coercive pressures in this situation than there would be in the station house, because a person in the station house can actually leave. And she could not. So I'm not sure that argument really helps you, but you know, in a real world, she could not leave. She was chemically handcuffed, in other words, to that bed, chemically and physically, by way of all of the catheters, lines, et cetera, that she was hooked up to. Leaving would have meant that she would have to disconnect herself, pull out her IVs, pull out her bladder catheter. I just find that kind of unreasonable, an unreasonable position to take here.
I understand, Your Honor, and that goes to my next point of People v. Perrenboom, a case where the defendant had actually lost her hands due to a bomb that she had placed herself. That was a 1997 Court of Appeals case, and in that case, they found that the defendant had not been considered arrested at the time. Defendant was not given Miranda, that no formal restraint had been placed on her freedom of movement, and the judge found that in this case, People v. Perrenboom, the defendant was actually worse off in that she didn't have hands to be able to even get up, help herself up, go out the door, that she was in a worse situation than the defendant in this case. And in People v. Perrenboom, the Court of Appeals found that Miranda was not necessary. As well, the officers there spoke to the defendant 3 times versus the 1 time over this 2-hour period in this instant case. Therefore, he found the environment less coercive. As well, that a reasonable person in her same situation would have felt free to terminate the interview. As Your Honor so kindly pointed out earlier, she was aware of how the process worked when she declined to speak to Officer Pettigrew earlier in the process. The trial court judge relied on his, I'm sorry?
Declined to speak to Officer Pettigrew. Has she been pumped full of drugs at that point?
That was early on in the process, Your Honor. That was when she was transferred from OMH headed to Sparrow. I believe she had some drugs in her system.
You know which ones?
I do not recall off the top of my head, Your Honor. I'm betting it's the same type of drugs based on standard of care. But as it was a lesser amount of time, she would not have the same amount of drugs in her. However, going back to the doctor's testimony, morphine does dilute out of your system over a period of time, which is why they had to keep giving it.
They gave her morphine and fentanyl, right?
Yes, Your Honor. The trial court judge relied on the audio tapes, the transcript of the hearing, the Walker hearing itself, and noted the statements were voluntary. Citing to this court's People v. Zahn case, noted she was not in custody. Citing the People v. Perrenboom case. The trial court judge followed the line of case law decisions crafted by this honorable court in arriving at its decision. Therefore, the people respectfully ask that this honorable court find that defendant's statements were voluntary and the defendant was not in custody for purposes of the Miranda prior to questioning. Thank you for your time.
You guys can take off if you want to. I think he's had enough. Nice to have you here, Leo. Come back someday, okay? See you later. He's 4.5. He'll get over it.
Your Honor, just a brief rebuttal, just to make 2 points. As it relates to the first time, that decision is completely silent as to whether or not the defendant in Perrenboom was immobile, could not leave the hospital, and it is unclear if she was told she could leave or if the police told her they would leave. So to that extent, it's very hard to know the factual similarities between Perrenboom and the instant case. And then lastly, Judge Gleicher, You made a number of what I would think are good points about the the medical records and the medication that was and the medical expert who testified at the Walker hearing. But I would also just remind the court that it wasn't just the defense expert, but also within Ms. Monroe's medical records, also the hospital staff noted her sort of being a poor historian, having a bad memory, those type of things also how the drugs had affected her as well as her injuries. And I would just ask the court to be mindful of that as well. Thank you.
Thank you very much. The case will be submitted.